In this episode, we talk about the demand for a Maratha Quota in Maharashtra and the challenges in implementing it. We also talk about children missing the measles vaccine in India and what the World Health Organization has said about it. But first, we talk about Tamil Nadu Governor R.N. Ravi. Hi, I'm Shashank Bhargav, and you're listening to Three Things, the Indian Express news show. Governor R.N. Ravi has recently made headlines for withholding his assent to a total of 10 bills that were approved by the Tamil Nadu government. And interestingly, this development coincides with at least 4 state governments, including Tamil Nadu, filing pleas in the Supreme Court seeking its intervention in defining the governor's powers in the lawmaking process, basically seeking clarification on what a governor can and cannot do while passing a bill. In this segment, we are joined by Indian Express's Apurva Vishwanath to talk about the governor's role and their tussle with state governments. Apurva, begin by telling us what is supposed to be the role of the governor in passing of a particular bill.
So, for every state government, it is the governor's seal of approval that makes a bill into a law, which means that after the legislative assembly passes the bill, you need the governor's assent for it to become law. This is how we have the president to sign off on whatever bills that the parliament passes. So in that sense, the governor is part of the legislature for this process. And Article 200 of the Constitution talks about what exactly can the governor do in these situations.
And Apurva, why is the governor required for this role? What does our Constitution say about this position?
So the governor is the head of a state, like the president is head of the country. They are the first citizens of the state, so to speak. And this practice of having the office of a Raj Bhavan is, of course, a colonial import. In the 1935 Government of India Act, the role of the governor generals, who are agents of the crown, so to speak, that role was fleshed out. And the 1935 Act really is the blueprint for continuing with the office of the governor even after independence. Of course, in the Constituent Assembly, there was a lot of discussion about whether we should have this post at all. And if we do, what should be the powers and limitations on the role of the governor. And Ambedkar is very clear in, his speeches in the Constituent Assembly that this position is more ornamental and the governor would have limited and nominal roles when it comes to his functions in the state. So the governor has no real powers that way, but is aided and advised by the cabinet, which means the elected government is really the head of the state, but nominally it is through the governor that the elected government rules.
And in the past, we have seen a lot of tussle between state governments and governors, especially when it is an opposition-ruled state, because the governors are appointed by the centre.
Yeah, so the governor in our constitutional scheme is an agent of the union. In fact, if you look at how Supreme Court proceedings happen when governors are involved, because it's a constitutional office, the governor is not directly impleaded as a party to the case. In fact, the notice goes out to the MHA and the secretary of the governor. So, the governor is not directly even brought into this litigation, although the governor's actions are what, the basis for this litigation. It is to that extent that the governor is an agent of the union government.
And Apurva, talk about what kind of powers does the governor have? What are the things that being in this position they can or cannot do?
So a lot of issues when it comes to the role of governor, whether it be recommending the imposition of president's rule or inviting a party to form the government, these things have been litigated upon and more or less we have settled case law on this. These are the usual confrontations with the governor that we see. However, there's one more crucial aspect where a governor acts rather independently, uses his own discretion and does not entirely go by the aid and advice of the cabinet. And that is his role as part of the legislature. That is when it comes to passing of bills in the state legislature. Here, Article 200 essentially gives the governor 4 options. Once a bill has been passed, the governor can either grant assent to the bill, withhold the assent to the bill, or return the bills for reconsideration, which means that, in part or full, the governor can say the legislature must discuss and debate this once again and reconsider the bill. Or the 4th option is when, for certain bills, the governor can reserve it for the president's assent. That is, there could be certain bills which the governor, say for example, if it is doubtful whether that subject matter falls in the union list or in the current list where this union has also legislated on a particular aspect, there the governor can reserve these bills for the consideration of the president. Otherwise, the governor either has to grant assent, withhold assent, or return these bills for reconsideration.
And what happens in the case where the legislature reconsiders a bill and sends it back to the governor?
So, when a bill is sent for reconsideration and the legislature reconsiders and sends it again to the governor is bound to give assent to that. So, which means again, the language of the provision is such that the primacy of this decision lies with the legislature. It is only the governor's seal of approval that is required and not, his own thinking as to whether this law is constitutional or not. There could be some situations where, say, a legislation is patently unconstitutional. Like if Tamil Nadu were to pass a law saying abolish the Madras High Court. Something like that, the governor can validly say, this is not a bill that I will sign on, or this cannot happen in the government that runs on my name, right? But for most other things, the governor is to either give his assent or send it back to the house. The problem here, in case of R.N. Ravi in Tamil Nadu or Arif Mohammad Khan in Kerala, you've seen opposition-ruled states now going through this, where the governor withholds the assent for an inordinate amount of time, say about a year or two. And the language used in Article 200 is the governor may as soon as possible. So as soon as possible is what defines how this provision works. The governor says as soon as possible is, say, 2 years, for example. The government, on the other hand, would argue that 2 years is basically paralyzing the legislature. You're keeping this in an indefinite limbo. And in 5 years, the government also expires. So how do you deal with situations like this? This is something that has now come to the Supreme Court for consideration.
So I'm guessing one of the things that these states that have gone to the Supreme Court want to know is whether the governor can sit on a bill indefinitely.
Yeah. Because it's a constitutional office and the constitutional itself does not prescribe a timeline. Governors have been using it for their advantage, and especially becomes problematic in this fraught political climate when it is an opposition-ruled state, right? So state governments want the court to now define this provision and say, for example, issue fixed timelines for governors to follow.
Right. And besides defining a timeline, is there anything else that these states are looking for from the Supreme Court?
So, Shashank, the other parallel we have, which is also something that, we've seen being litigated, is the time a speaker takes for disqualifying a member from the House. Say, in the case of an MLA jumping parties, for whatever reason, the MLA has to be disqualified. And we've seen a lot of these close calls being made when it comes to disqualification, like say in the case of Karnataka or recently the Maharashtra government. So where governments can collapse because the disqualification proceedings have not happened swiftly, right? So in the case of Maharashtra, the disqualification is still pending despite Supreme Court strictures that it should happen within 6 months. So the speaker again holds a constitutional office like the governor, and the constitution itself does not fix a timeline for the speaker to decide on these disqualification proceedings before him. But that does not mean the speaker can sit on it indefinitely, because that would defeat the purpose of the law itself. Similar to the governor's role here, withholding assent to these bills indefinitely means you're failing the government that runs on your name. Which is why courts have been sort of reluctant to step into this space, because they're all constitutional offices and one constitutional office cannot be prescribing limitations for the other constitutional office. Which is why in the first hearing, Chief Justice of India, D.Y. Chandrachud, called for some soul searching by, all the governors and chief ministers. They said, why should you come to the court? Why can't you settle these issues amongst yourself through a dialogue? And only when that didn't happen, that, states again went back to the court and want this issue sort of litigated. Yeah, one way would be the Supreme Court taking a strong call on this and maybe not passing orders saying within 3 months or 6 months, but saying if there is an inordinate delay, that the court would intervene. Entertaining more cases like these would itself send a signal to the governor. We've seen that happen in the case of President's Rule. From the 60s and 70s, you'd had this provision been misused very, very frequently by then Congress government, right? Wherever there was an opposition rule government, the governments would collapse because the governor would recommend President's Rule. But a bunch of cases, repeated court interventions, have now sort of settled the law on this issue, and there are strict lines that the governor can and cannot do.
And next we talk about the demand for a Maratha Quota. For some time now, the Maratha community in Maharashtra, comprising a little over 1/3 of the state's population, has been demanding reservation in government jobs and educational institutions. This demand actually goes back to the early 1980s, but has gained a lot more attention over the past 2 decades, marked by protests occurring across the state. And this is what had led the BJP government headed by Devendra Fadnavis back in 2018 to give in to this demand.
So in 2018, when Devendra Fadnavis was the chief minister.
That's Indian Express's Shubhangi Khapre, who reports on Maharashtra for the paper.
In 2014 to 18, when he brought an act, the State Backward Class Commission was constituted, and they kind of studied a report which was based on the actual door-to-door campaign kind of thing to actually find out how many Marathas are poor, how many have illiteracy, that kind of thing. Now, those are the facts on which they submitted a 1,000+ page report, and the Backward Class Commission, which was led by M.G. Gaikwad, they considered it as a community which is socially and educationally backward community. And based on that, they were given reservation of 12 and 13% in education and employment, government employment, I mean.
But later, in 2021, the Supreme Court scrapped this decision, saying that this move was breaching the 50% reservation ceiling and that Marathas did not classify as a backward community.
See, the biggest hurdle in Maratha reservation is Marathas as a community is a very influential community, and they have in the entire history of Maharashtra and even pre-independence, if we look at right from Chhatrapati Shivaji Maharaj era, the warrior king, they have never faced discrimination based on the caste, community or subcaste. So they were always in the forefront. And today, so on what basis can you consider them as backward? Because when Indian Constitution was made, the definition of backwardness was very different. It was not essentially centered on educational and economic backwardness. It had the backwardness related to the social stigmatization, which the Marathas have never faced in the entire historical past, if you see.
But despite this, protests for the Maratha Quota have continued to take place even now. In this segment, Shubhangi tells us how these protests have evolved and how likely the government is to act on it. Shubhangi, could you talk about how the nature of these protests have changed over time, especially after the Supreme Court's decision?
Yes, this whole protest, I mean, if we just draw a comparison between 2018 and now, in 2018, it was a very organized kind of a protest where nodal agency, the Maratha Kranti Morcha, the nodal organization, that led the protest. That protest was leaderless. That protest was not political in the sense that it did not give platform to established political leaders or the parties. So they came up with a kind of a strategic decision where a group of people, with the support of course, the established leaders, but they were put in the background and they were the front face and they represented the Maratha community. Now, those protests was very volatile in the sense it elicited huge response. I mean, across Maharashtra, that was also for the first time it had come up on that magnitude. It was a mammoth scale, I mean, unimaginable in the recent decades, we can say. Now, compared to that, this September 2023 protest is led by a single Maratha activist called Manoj Zarange Patil. Now, he is a villager, from a very humble background, and he's a frequent protester, but not a leader in as such. Like, he was not an established leader. He doesn't belong to a very any political party in that sense. Now, when he started the protest at village Antarwali Sarati in Jalna district of Marathwada region. Initially, there were only 14 villages in the neighborhood from where there was a support kind of him or to that. But what happened later is there was a police lathi charge, and that created a lot of hue and cry, and then everything went viral on social media. And all the community people, Marathas, as well the organizations which was dormant in the last 2-3 years, they also started associating. And it became again a big movement, which we are witnessing now.
Right, and in that sense, this entire protest is now driven by just one activist, Manoj Zarange Patil. But the Supreme Court had pointed out that the community does not qualify for a reservation because they're not a backward community. So considering that, what do people who are protesting want the government to do? How do they want this reservation implemented?
Yes, it's a very complex issue. The whole problem is Maratha community is not a backward community, strictly in terms of what constitution has defined as backward.
Yeah, this is what the Supreme Court had said as well.
Yes, the Supreme Court's argument was that the first thing is it's exceeding 50% ceiling. But more importantly, the issue was, how do you prove it is a backward class community? Now, the Supreme Court, while scrapping the decision, had also said that you provide empirical data, because whatever the base on which you have given the report is, there are a lot of flaws in that. So they said you come up with the empirical data and you establish like how it is backward community. If these two conditions are conformed to, then the Supreme Court would reconsider. Now, these two conditions in the last 2 and 3 years, none of the government, whether it's Mahavikas Agadi or present government led by Eknath Shinde, they have not fulfilled those two conditions.
Right, and the demands for this were dormant for some time, but they came up once again and were led by activist Zarange Patil, who had gone on a hunger strike for 17 days. Talk about what happened after that.
So it alarmed the state government because they suddenly realized if his health was deteriorating, it could again snowball into a major social issue, basically. So hurriedly, the chief minister gave a promise saying that, yes, whatever you're demanding, we will concede. But the catch here is that Zarange Patil also, first he restricted his demand only to Marathwada, that is of 8 districts. He said in revenue record or education record, if anybody is found to be Kunbi, you consider them for reservation.
Wait, can you explain who the Kunbis are and how they differ from the Marathas?
So a Kunbi is a subcaste of Marathas, but basically Kunbi, Marathas and Maratha Kunbis are almost the same. That's what the experts say. Because Maratha community, if you go back in the historical past, they did agriculture and also were involved in the military kind of action or, warrior, their ancestors. So it's very difficult to discriminate, whether they are Kunbi or they are Maratha. So one theory is that Maratha and Kunbi are the same. Now, if you see Vidarbha region of Maharashtra, which is the most agriculturally vulnerable place, there the Kunbi Marathas are already availing reservations since 1992 when Mandal Commission was implemented. But the Western Maharashtra, which was economically prosperous, there the Marathas took the pride that we are forward. And at that time, they did not want to be a part of the backward community in the past. This I'm talking about 1960 onwards when the state was created. And even then, there was this appeal that, the Marathas should be considered as backward, but they had refused that.
So is the dilemma for the government about whether to consider the Kunbis as Maratha or not?
Yes, Marathas or not. And now the whole problem is in part of Konkan, that is again the coastal stretch of Maharashtra, and Vidarbha, the Kunbis are already categorized as OBCs. But Western Maharashtra and Marathwada and North Maharashtra, these 3 regions, there's a question mark now. Now, the whole problem is CM has conceded to his demand, saying that, yes, we will consider this. But later on, this activist who's on protest, Zarange Patil, he said the Kunbi certificates should be issued to Marathas across the state. Now, that demand, which he changed, has put the government in a fix. Because had it been only for Marathwada region, it would have been, limited kind of a numbers and it would have been easier to incorporate. But again, the whole issue would be somebody would have challenged it. And again, the whole matter would be why only Marathwada, not the other part of the Maharashtra. So it's become very complex right now.
Right. And could you talk about how the OBC community in the state has reacted to this proposal?
So the OBCs, which is 52% of the population, they have already made it clear that they will not allow inclusion of Marathas within OBC category. So the OBC leaders, the state OBC leaders, the local OBC leaders, all of them, they had a huge rally the other day also at Jalna. And they have made it very clear that you give them separate quota, but it should not be included within the existing OBC quota in Maharashtra. So that's where the whole question mark is now. How are they going to resolve the issue? So what the government has done is they have formed a committee led by a retired justice of Bombay High Court, Sandeep Shinde. And On the one hand, the scrutiny of document is going on, who is Kunbi and who is not Kunbi, that kind of thing. At the same time, this committee the government is also again referring the whole issue to the Backward Class Commission, because these two issues have to be resolved, which the Supreme Court had demanded: empirical data, furnished empirical data, and at the same time also kind of establish how the Marathas are backward class. So these two conditions which the Supreme Court had laid down are being looked by the Backward Class Commission again. And if they can establish, then the government will approach the court with the condition that yes, since it has been established as Backward Class Commission, we propose a separate reservation of say 10%, 8%, whatever they come up with at that time. They might come up with a resolution in the winter session of State Legislative Assembly in Nagpur that is commencing on December 7th. So it will be all party consensus. There has to be uniformity in this. In principle, all political parties are in support of Maratha reservation. But the whole problem is how do you give and what will be the formula. So, but inclusion of Marathas within OBC is completely ruled out at this moment, because OBCs are a sizable force to reckon with, and no political party, irrespective of their support to Maratha reservation, can afford to antagonize OBCs at this moment.
And in the end, we talk about vaccination for measles. A recent report by the World Health Organization and the United States Center for Disease Control and Prevention revealed that around 11 lakh children in India missed their first dose of the measles vaccine in 2022. When we spoke to Indian Express's Anonna Dutt, she told us that the COVID-19 pandemic had a huge role to play in it.
So globally, there was a decline in all childhood vaccinations, including measles vaccination during the time of COVID, because most of the health infrastructure was busy with dealing with the impacts of the pandemic. But a lot of countries did see an increase in their numbers of vaccination in 2022 when the number of COVID cases started going down. However, the WHO report, which looks at the India's data from 2022, says 11 lakh children did not get their first dose of the vaccine in India.
And she says that this led to a measles outbreak in the country last year, eventually prompting the government to conduct a special vaccination drive. To know more about the outbreak and the measures taken by the government, my colleague Ucha Sarman speaks to Anonna in this segment.
Anonna, can you first tell us why this WHO report is so significant? What kind of concerns do missed measles vaccines raise?
So, measles is an extremely transmissible virus. In fact, it's more transmissible than COVID-19. So, if people are not vaccinated, and it mostly affects children, if they are not vaccinated, the disease can spread very quickly in clusters. So, the concern was that globally, when there was a dip in measles vaccination, and you have to maintain a very high vaccination level to ensure that measles doesn't spread. So, as soon as there was a drop in 2020 and 21, there were outbreaks, including in India. So in 2022, India saw an outbreak which was in at least 5 states, including Maharashtra, where 13 measles deaths were reported. So when there is no vaccination, A, it increases the chances of outbreaks in these unvaccinated clusters, and B, measles is a vaccine preventable disease. And while the infection itself causes, just fever and cough, rashes on the skin, it's the complications that can be deadly, such as pneumonia, difficulty breathing, excessive diarrhea, and things like that, which can ultimately lead to death.
Right, and how did the government respond to these rising cases and the deaths that happened due to measles?
So one of the strategies that government did include was vaccinating the children living around these regions wherever there were measles cases. So the cases were reported from Bihar, Gujarat, Haryana, Jharkhand, and like I mentioned, Maharashtra. So in these states and in states around the neighboring states, children were vaccinated for measles, children between the ages of 9 months and 15 years to prevent the spread. Other than that, there was also the intensified mission Indradhanush, which started at the beginning of the year, and the 3 rounds were completed in October. What intensified mission Indradhanush does is reach out to the children and the mothers who've missed out their vaccination and cover it. So by the end of 2023, the government officials say that we've been able to cover almost all of this gap.
And apart from this, we also understand the government has a vaccination drive for older children as well. So tell us about that and the extent to which that has helped.
So the measles vaccine was introduced in 2017, which is the MMR, measles and rubella vaccine. It was introduced in 2017 as a part of the government's commitment to eliminate measles and rubella by 2023, which is the target of all the WHO Southeast Asian region countries at the moment. So when it was first introduced, of course, the routine immunization happens in children between, under the age of 5. So there was still a large cohort of children who were left out from this vaccination. And to cover that population, there was a one-time drive that was started to vaccinate children up to the age of 15 years. And this was carried out in a phased manner in different states, with only West Bengal and Delhi remaining unvaccinated at the beginning of 2023. And in January, even the West Bengal covered these older children. However, with Delhi, there were some cases which were pending regarding consent from 2019, if I'm not wrong, because of which the vaccination in Delhi got stalled. So children up to the age of 5 were vaccinated in Delhi.
Right, and Anonna, other than the issue of mixed vaccinations, has the WHO raised any other alarms about the status of measles in India?
So not particularly. They did say that 2022 we had an outbreak, which is the case where, as I discussed, that the vaccination was carried out in response to these outbreaks. But other than that, the report did not really highlight India, because India over the years has improved surveillance as well. And one of the experts that we spoke to for the story, in fact, said that we are currently meeting better than global standards of measles surveillance. So that's a good point. And we have now again reached a point where measles vaccination has also reached saturation, which means that our measles elimination target is going well.
You were listening to 3 Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargav, with help from Utsha Sermon, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcast@indianexpress.com.